Welcome to the third in a series of 5 videos where we are looking at some fundamental concepts in jurisprudence, the philosophy of law. In this video we are going to look at legal positivism. The previous video was concerned with natural law theory, which we saw was a school of thought within jurisprudence that insists that the laws made by the state must be consistent with the natural law, which was a set of rules and principles that existed in the universe and which determined what was right and what was wrong, what was good and what was evil. Legal positivism is a more scientific approach to understanding the nature of law. Legal positivists insist that we should focus not upon what the law ought to be or should be, but what the law is. And what the law is something that is created by human beings. It is a social construct. This is known as the social thesis. Legal positivists also insist that there is no necessary connection between the law and morality. This is known as the separation thesis. This is another way in which legal positivism differs from natural law theory. We saw that natural law theorists insist that the law must be consistent with the principles of morality, and that in fact some natural law theorists insist that if a human-made law is not consistent with the natural law, then it is not really a law. Recall Cicero's lex injusta non est lex. Legal positivism emerged as a school of thought around the time of the Enlightenment, when European society began to move away from a religious understanding of the world and towards a more scientific understanding of the world. John Locke wrote, "The appropriate subject of jurisprudence in any of its different departments is positive law, meaning by positive law, or law emphatically so called, law established or positum in an independent political community by the express or tacit authority of its sovereign or supreme government." As we can see, Locke is insisting that our understanding of law need not have anything to do with natural law or universal principles of morality and justice. Jeremy Bentham insisted that there is a distinction between the expositors, who are the people who explain what the law in practice is, and the censors, who criticize the law in practice and compare it to their notions of what the law should be. Bentham insisted that we should not be concerned with what some people think the law should be, and rather our focus should be upon what the law is. The purpose of the philosophy of law is to explain the real laws of the expositors, not the criticisms of the censors. John Austin famously developed the command theory. The law is a set of commands from a sovereign that are backed by a threat of sanction. Note, again, there is no reference to justice, no reference to morality, and in fact Austin's notion of what law is has in many ways become common sense for legal academics and law students today. The law is a set of commands made by the state or by the government and that are enforced by way of some form of sanction. In the 20th century, Hans Kelsen developed a very sophisticated model for understanding the nature of law. According to Kelsen, law is a scientifically rational system of coercive norms that form a hierarchy. A norm is a statement about the way a person should behave. So a rule is a type of norm. Each norm within a legal system is validated by a superior norm. For example, if I'm driving my car and I see a stop sign on the side of the road, there is a rule that I should stop my car at that stop sign before proceeding. Now this particular rule is validated by a superior rule, and that superior rule is set out in the regulations to the Traffic Act. The rule is that wherever a stop sign appears, the motorist has to stop their vehicle at the sign. But what makes that a valid rule? Well, it's the fact that the regulations are attached to a piece of legislation, the Traffic Act. And there is a rule within the Traffic Act that states that any regulations made attaching to that act must be treated as if they are part of that act. But what gives the Traffic Act itself validity? Well, it's the fact that it was made by the Queensland Parliament, and there is a rule that any legislation passed legitimately by the Queensland Parliament is law that we must all obey. But what gives the Queensland Parliament its validity? Well, there is a superior norm, the rule that is set out in the Queensland Constitution that states that the Parliament is empowered to exercise legislative power within our legal system and make law. But what makes the Queensland Constitution a valid norm? Well, it's the fact that it was passed as part of legislation by the UK Parliament. But what gives the UK Parliament validity? And so on. So every rule is validated by a superior rule within a hierarchy of rules. Now, the ultimate norm, from which every legal norm deduces its validity, is called by Kelsen the Grundnorm, the highest basic norm. And what is the Grundnorm? Well, for Kelsen, it differs from legal system to legal system and is ultimately a non-legal, usually a historical or political event or situation. H.L.A. Hart developed a more nuanced form of legal positivism, one which rejected the command theory that we saw earlier as too simplistic. Now, you will recall that the command theory stated that a law is a command issued by a sovereign and enforceable by sanction. Hart said that this is too simple. Rather, the law is a system of primary and secondary legal rules which derive their legitimacy from an ultimate rule of recognition. A primary rule is the type of rule envisaged by the command theory. It's a rule of conduct. It's a rule that tells us what we can or can't do and the consequences of disobedience. We cannot, for example, exceed the speed limit, and if we do, we will have to pay a fine and lose points off of our license. We cannot breach this particular term of our employment contract, otherwise we may be dismissed. According to Hart, however, there are many rules within a legal system that are not primary rules. They are not rules that tell people what they can and can't do. Instead, they are secondary rules, rules that regulate the creation, extinction, and alteration of primary rules. Most of contract law, for example, is comprised of secondary rules rather than primary rules. Hart's rule of recognition determines the ultimate validity of a primary or secondary rule. It derives its own validity from being accepted and adhered to by legal officials. Hart did have something to say about the relationship between law and morality. As you'll recall, natural law theorists insist that law must be consistent with the principles of morality, whereas legal positivists insist that there is no necessary relationship between law and morality. Hart was a legal positivist, but he did insist that laws have a minimum moral content to encourage adherence. In other words, an immoral law is less likely to be obeyed by the citizens.